Welcome, everyone, and thank you so much for joining us. We're just giving it a quick minute while folks filter into the virtual room. Great. Well, hello and welcome, everyone. I'm Keith Tyrion, Vice President of Strategy at Alliance for Justice. Thank you so much for joining us this evening for our session of our most recent holding court talk. Amidst the momentous decisions of recent weeks, last week we celebrated the swearing in of the first Black woman to the US Supreme Court, the first in the year of 2022. It's remarkable to see this historic moment, and even more remarkable that it's taken this long to get here. Still, here it is, and it would not have happened without so many of you joining us this evening who support AFJ's work and were part of this fight with us. But I'm fully aware that this is one of the few reasons to be celebrating and rejoicing in this moment. We are deluged daily with new revelations that demonstrate that our democracy is unfair and unraveling. The January 6th hearings are a near daily diet of the unbelievable, and the Supreme Court's rulings on abortion, on gun control, on climate change, on Native sovereignty, and most relevant for today, on the rights of the accused in the face of police aggression. Each of these rulings confirm that we are accelerating that unfairness and unraveling. And in the Supreme Court's case, we're on this path allegedly in the name of our Constitution. That's why tonight's conversation is so timely. In his latest book, Dean Erwin Chemerinsky provides a vital service to our national conversation on race and police violence by revealing the court's complicity in our current moment. With brief exceptions, he argues that the Supreme Court has engaged in a long-term campaign to empower police misconduct at the expense of our Constitution and, more importantly, the very lives of our fellow citizens and human beings. From the late 18th century until today, flagrant police violence and abuse has been dismissed by this court. In other words, it was more common that the court advanced police terror than honored the Constitution's commitment to limiting excessive force by state authorities. Then came the rare and exceptional rulings of the Warren Court in the 1960s. During the Warren years, the court held that individuals have the right to an attorney in criminal proceedings and the right to remain silent during police interrogation. It held that evidence illegally obtained by the police cannot be used to prosecute someone in court, and that accused individuals had the right to fair police lineups. But this protection of the accused was both novel and short-lived. Again, despite the framers' fear of police power and desire to constrain police, when the Warren Court came to a close, the court, time and time again, ignored the rights of individual defendants, chipped away at the decisions of the Warren Court, and ruled for the state. To state the obvious, Dean Chemerinsky's book could not be more essential in this moment. While millions of Americans rose up in 2020 to protest systemic racism and the murders of George Floyd, Breonna Taylor, Ahmaud Arbery, and so many others, the court has continued to hand down opinions that thwart police accountability. Just last month, the court made another deplorable mistake when it ruled that a police officer may violate your Miranda rights and you have no recourse to a civil rights suit under Section 1983. For those who have studied the court, like our esteemed panelists this evening, this undoing of protections is not a complete surprise. However, the boldness and cruelty remain shocking. The court, overtaken by Trump nominees working hand in hand with other conservative extremists, is being weaponized against the majority of us on issues of police violence and so many others. Alliance for Justice has long advocated for a judiciary that protects the vulnerable and guarantees the rights and privileges of the law to all people. Tackling this issue head on helps us in our work to root out systemic racism in our court system and create one with the respect and reverence for our most precious civil rights. We look forward to this conversation and hope it's the first of many that leads to reform of a badly broken and deeply politicized court. We look forward to a strengthened focus on jurists who will uphold the Constitution and hold police accountable for their enforcement of our laws. And we need legislators and executives unafraid to end the unconscionable doctrine of qualified immunity. Our panelists this evening are author of Presumed Guilty and Dean of University of California, Berkeley School of Law, Erwin Chemerinsky, and Deborah Archer. Dean Chemerinsky is also the Jesse H. Schoper Distinguished Professor of Law at Berkeley. He's a prolific writer and scholar. He's the author of 14 books and over 200 law review articles on constitutional law and criminal procedure. Dean Chemerinsky is joined in conversation tonight by Deborah Archer, who's known to AFJ from our president Rakeem Brooks' days at the ACLU. She's a professor of clinical law and co-faculty director of the Center on Race and Equality in the Law at NYU School of Law. She's also the president of the American Civil Liberties Union National Board and a leading expert in civil rights, civil liberties, and racial justice. Before I turn it over to Deborah and Erwin, I want to remind you in the audience that we'll turn to your questions at the end of the program. Please use the chat to submit your questions or the Q&A tool at the bottom of your screen. And now please join me in welcoming Dean Erwin Chemerinsky and Deborah Archer. I'll turn it over to Deborah to kick off our conversation, and thank you again for joining us this evening.
Thank you. Thank you, Keith, for kicking us off and for the introduction. Thank you for inviting me to be a part of this conversation. Erwin, it really is such an honor to spend this time speaking with you. Before we began, you and I were reminiscing and were reminded that we were last together when we were debate partners in a debate around affirmative action, another issue that is about to be before the Supreme Court. So maybe we'll reunite to discuss that issue. But I really enjoyed this opportunity to read Presumed Innocent, and I think we should show the book. Even as a person who spends time thinking about these issues and all of the questions that Keith raised in the introduction, I still learn so much. You have the ability to effortlessly walk readers through this relationship between the Supreme Court and the police that we really don't see every day, and talk about the building blocks the court laid down that helped us get to where we are today, where we're still seeing repeated examples of racialized police violence. We had the historic protests demanding accountability, demanding transformation, demanding justice. Yet today we see very little of any of that. And I'm hoping you'll be able to help us understand how we got here and the court's role in all of that, which really will be the focus of our conversation today. But before we get into that, I want to start from the beginning and ask you why you decided to write this book. You really are a prolific writer and write about many topics. You are an expert on many, many topics. Why did you think that this was the topic that you needed to explore at this point?
Thank you so much for doing this, and it's such a pleasure to get to be with you. I taught criminal procedure at Berkeley Law in the fall of 2019, and I realized that what we say exists in terms of rights is so different than the reality with regard to the criminal justice system. As you know so well, the criminal justice system is tremendously racialized with regard to policing and all that follows it. And as I went through the course for each topic, it was how the Supreme Court has failed to protect the rights of suspects and criminal defendants, how in each area, the Supreme Court has empowered racialized policing. And in January of 2020, I signed the contract to write the book and had in mind I was going to take a couple of years to do it as normal time to write a book of this scope. Of course, in late May of 2020, there was the tragic killing of George Floyd. There were the protests in literally all 50 states. My editor, who I learned is also your editor, Bob Weil, said, "How soon can you get me this book?" And we agreed that I would have the manuscript to him by the end of October of 2020, just a few months later. And you also know what it's like when you're under that kind of a deadline, while also teaching class, being a dean and everything else. But the timing was so important. And it touches on something you just said. I have to tell you, when I wrote the book over the summer of 2020, I had a real optimism that all of the attention on racialized policing and police violence was going to really make a difference. And now, as we talk just 2 years later, it's more discouraging. It didn't happen.
Yeah, I think about that as well, that it didn't happen. that after all of that, the attention, the eyes, not only of everyone in the country, but the eyes of the world were on us. And it seemed like we had momentum and power to push forward and make deep change. And you said that we haven't lived up to the promises in our Constitution. When I think about the work of the ACLU, the work that I've done as a civil rights lawyer, I think about it in the context of trying to bridge that gap between the America that was promised and the America that is. And instead of seizing this moment to close that gap, it seems like we've widened that gap.
I think that's right. And it's important to recognize that racialized policing and police violence continue. This is just a short time ago that Jalen Walker in Akron, Ohio, an unarmed Black man, was shot 60 times by the police and killed. And yet that didn't capture the public imagination. There's not the same protests as with the death of George Floyd. But we could go on for instances since the death of George Floyd. And then there are all the ones that we never hear of that occur on a daily basis. And we're focusing on one aspect of racialized policing. We can also talk about all of the racial profiling that occurs with regard to police stops, all of the abusive police behavior that happens, the failure to protect people from discriminatory lineups and false identifications. There's an enormous problem in the criminal justice system. And yet I worry that the impetus for reform is, at least for now, faded.
Yeah, I want to turn to the book. A lot of the folks who are joining us today are familiar with some of our more basic constitutional protections in the criminal legal system context, like the right to counsel in Gideon and the right to remain silent from Miranda. And they were all from the Warren Court. I'm hoping you can take some time to explain the impact the Warren Court had in changing the relationship between individuals, communities, and the police, and establishing rights for people accused of a crime.
I think it's important to put the Warren Court in a historical context. For the first more than century of American history, the Supreme Court decided no cases limiting the police. And the Fourth Amendment is there to limit how the police stop, search, arrest people. The Fifth Amendment is there to protect the privilege against self-incrimination. Due process is there to limit so many police practices. But you would search in vain for any Supreme Court precedents with regard to the Fourth or Fifth Amendments for the first century of American history. And then for the next half century, when there were cases, except in the most extreme facts, the Supreme Court sided with the police. The Warren Court was unique. It's the only time in American history where there's a liberal majority on the court. We often forget that really was just the period from 1962 to 1969, though the Warren Court existed from 1953 to 1969. And you're absolutely right that the court then did things that had never done before and they've been cut back on since. I'll take your examples. In 1963, in Gideon versus Wainwright, the Supreme Court said that anyone who's tried in state court where there's a possible prison sentence has a right to a lawyer, and if the person can't afford one, the government has to provide one. Isn't it astounding to us that for the first 172 years of the Bill of Rights and the Sixth Amendment, a person could be tried in state court, even sentenced to life in prison, without needing to be provided a lawyer? In 1961, in Matt versus Ohio, the Supreme Court said that if state and local police violate the Fourth Amendment, any evidence gained has to be excluded. Again, we can pause and say, isn't it amazing that for the first 170 years of American history, police could blatantly violate the Constitution, and yet the evidence would be admissible? In 1966, in Miranda versus Arizona, the Supreme Court said, when police question people when they're in custody, it's inherently coercive. And to lessen the coercion, police have to give warnings. And the warnings that anybody who's ever watched a police show or a police movie is familiar with. It was in 1968, in a case called United States versus Wade, that the Supreme Court for the first time said, eyewitness identifications, like lineups, can be very suggestive. They can lead to conviction of innocent people. And therefore, it's a lineup that occurs after someone's indicted, The suspect has the right to have an attorney present. Again, we can put this in context that it was the first 177 years of American history that not one Supreme Court case limited what the police could do in eyewitness identification procedures. Now, just to go to the more recent, there has not been a Supreme Court case since 1986, when William Rehnquist became Chief Justice. There's only been one Supreme Court case about police lineups, and that ruled in favor of the police, even though the statistics show how many innocent people are convicted based on faulty eyewitness identifications.
So why are there so few cases that are getting to the more modern Supreme Courts that address these issues, or are they getting there and we're getting bad decisions?
Well, let me take lineups as an example. Because of the work of the Innocence Projects, we know that more than half of those who were later acquitted, that they were convicted and exonerated, well, the conviction was based, at least in part, on eyewitness identification. Social psychologists tell us all the reasons why eyewitness identifications can be faulty. We especially know that cross-racial eyewitness identifications are likely to be flawed. And yet, since 1986, there's only one case that's ever dealt with the issue of eyewitness identification, because the Supreme Court has denied review. And the Supreme Court has made real clear that lower courts should accept eyewitness identifications unless they're so extreme and unreliable. In terms of search and seizure, there have been a lot of Supreme Court cases about the Fourth Amendment, but time and again, the Supreme Court has sided with the police and against criminal suspects. Or take the Fifth Amendment privilege of self-incrimination. As mentioned in the introduction, there was a case about that just 2 weeks ago, but it ruled in favor of the police in limited remedies when the police violate Miranda.
Yeah, it strikes me that in you talking about these cases and the dates that they were decided by the Warren Court, how young these rights are, but how essential they are to our identity and discussion of constitutional rights and constitutional protections. And it seems like right after the Warren Court made these decisions, they started to undermine those decisions. And I think we've seen that in so many areas of the law, abortion rights. I think the day after Roe was decided was the day that they started to chip away voting rights, affirmative action. It's really been death by 1,000 cuts. And in your book, you make the case that the Supreme Court steadily rolled back, restricted, and unraveled these rights. Again, death by 1,000 cuts. Can you talk about how the court did that? You started to say that about denying cert and review in some of those cases. But can you go into more detail about how the court did that? And what were some of the transformational decisions that inflicted those cuts on the rights that you've been talking about?
In 1968, Richard Nixon ran for president against the liberalism of the Warren Court. And he especially focused on criminal justice issues. And he said he would appoint justices who were committed to strict constructionism of law and order. He was able to appoint 4 justices in a 2-year period. And the area where they most changed the law was with regard to criminal justice in policing. I heard somebody just the other day say that we're starting to have a conservative court now. No, the conservative court actually has been there since 1971. It's just now we have 5 justices more conservative than we've ever had, at least since the 1930s. But it's not as if there's been a liberal court in the 1970s or since, especially when it comes to policing and criminal justice. Let me give you just a couple of examples. I want to talk about a case from 1982 called City of Los Angeles versus Lyons. I intentionally chose to start the book with this. It involved a 24-year-old Black man, Adolph Lyons, who was stopped by Los Angeles police officers one night for wearing a burnt-out taillight. The officer ordered Lyons out of his car. The officer slammed Lyons' hands above his head onto the roof of the car. Lyons was complaining that the keys he was holding were cutting the skin of his palm. The officer thought that Lyons was mouthing off and administered a chokehold on Lyons. Literally, the officer put his forearm around Lyons' neck and squeezed. And he did so until Lyons was unconscious. Lyons awoke. He had urinated and defecated. He was spitting blood and dirt. The officer gave Lyons a traffic ticket and let Lyons go. Lyons did some research and discovered at that point, 16 people in Los Angeles had died from police use of chokehold, almost all like him, Black men. Lyons sued the city of Los Angeles for an injunction to stop officers from using the chokehold, except where necessary to protect the officer's life or safety. The Supreme Court, 5-4, with the conservative justice in the majority, said that Lyons lacked standing to sue for an injunction. The court said Lyons could not show that it was likely that he personally would be choked again in the future. The court said a person like Lyons wanting an injunction has to be likely to future personal harm. Well, this makes it impossible for virtually anyone to sue for an injunction to stop the chokehold, because no one can show they're going to be choked again in the future. I can tell you so many cases in the lower courts where people were suing to stop abusive police behaviors, strip searches, women stopped for traffic violations that got dismissed because the plaintiff couldn't show it would happen again in the future. What if the court had found the chokehold unconstitutional, like Lyons wanted? Maybe George Floyd, maybe Eric Garner wouldn't have been killed. I'll give you one more example that I think has made such a huge difference in opening the door to racialized policing, or at least legitimized racialized policing. It's a case called Wren versus United States from 1996. It involves some District of Columbia undercover police officers. They were driving. They said it was, quote, a high crime area, which is a euphemism for a community that's predominantly individuals of color. And it saw a car stop an unusually long amount of time at a stop sign, 20 seconds. They decided on the basis of this to follow the car until the driver committed a traffic infraction. At one point, the driver changed lanes without a signal. So they pulled over the car for the traffic infraction. In DC, the rules were that undercover police officers were not supposed to enforce traffic laws. They did it anyway. They ordered the driver and the passenger out of the car. They did a search of the area where the driver and passenger were present and found drugs. And the question is, did the drugs have to be excluded? Now, the traffic stop was a pretext. The officers were looking for drugs. Nonetheless, the Supreme Court ruled unanimously that the evidence was admissible. Justice Antonin Scalia wrote for the court and said, it doesn't matter why the officers stop individuals. Doesn't even matter if they're doing it on the basis of race. So long as they've got reasonable suspicion that there was a traffic infraction, that's a basis for stopping the car. When I was doing the research on the book, a police officer told me if he follows any driver for 15 minutes, he'll see a traffic infraction. Going a mile over the speed limit, changing lanes without a signal, not stopping long enough at the stop sign. And we know that the police use this discretion disproportionately against drivers of color.
I want to go back to your discussion of Lyons from decades ago and that particular tool of undermining rights and the ability to enforce rights. And both you and Keith mentioned the Supreme Court's decision in Vega last month that ruled that a person cannot sue a police officer under federal civil rights law for violating their Fifth Amendment right against self-incrimination by failing to provide the Miranda warning. And by denying people whose rights are violated the ability to seek redress under some of our country's most important civil rights statutes, the Supreme Court really further widens that gap between the guarantees found in the Constitution and the Bill of Rights and the people's ability to hold government officials accountable for violating them. What do you see as the impact of Vega? And what are ways that the court might continue this practice? What are other rights that are at risk with this kind of tool of undermining?
Rights are meaningless unless there's remedies when they're violated. Now, we were talking about the scope of rights. For example, how Wren lessened the Fourth Amendment protections, or there aren't rights against suggestive police identification. But the court can also undermine rights just by making sure there's no remedy. The importance of Lyons is to make it very difficult to ever sue law enforcement for injunctions for reform to remedy even systemic constitutional violations. Another form of remedy is damages. Well, Vega versus Tico, the case you mentioned, said that if police violate Miranda, there's no damages that can be sought, even if somebody has been harmed greatly. I have to disclose, I was co-counsel for Tico in this case. And what involves is a situation where a man was brought by a police officer into a small room. He was questioned in a very intimidating, aggressive manner. Even though he was in custody, he was never given Miranda warnings. He made some statements. He was tried. He was acquitted by the jury. And he sued the police officer and said, "You violated my rights, and this caused me enormous harm." And the Supreme Court, like all the recent cases, 6-3, Justice Alito writing, said there's no remedy there. But I think it's important to recognize this is just one of many cases where the Supreme Court has negated a remedy. There's another case just a few weeks ago called Agbert versus Bull that said when a police officer, he was a border agent, violated somebody's rights, there couldn't be any lawsuit brought. The Supreme Court said federal officers can't be sued for constitutional violations at all, which is really astounding when it comes to ability to sue for money damages. And then we can talk about, this was mentioned in the introduction, how the Supreme Court has greatly expanded qualified immunity, which again means there's not a remedy there for people whose rights are violated. So I think it's important that we're talking both about how the court is narrowing the scope of rights, but also how the court is denying remedies, even when there are rights that are violated.
And can you pause for a minute in talking about qualified immunity? We hear the term a lot, it's thrown around a lot. Can you explain exactly what it is and how the court created it and uses this doctrine to empower the police and restrict the ability to hold officers accountable?
There's a federal statute, 42 United States Code, section 1983. It was adopted in 1871. And it says, whenever any state or local officer violates the Constitution, the person can be sued for money or an injunction. And the Supreme Court has said, whenever any government officer is sued for money, they always have an immunity defense. Now, there's no statute that says this. The Constitution says nothing about it. The Supreme Court made it up in interpreting section 1983. And some government officers have absolute immunity. They can't be sued for money damages, no matter how egregious the constitutional violation. Judges for their judicial acts, prosecutors for their prosecutorial acts, even if they intentionally prosecute and convict an innocent person, can't be sued for money damages. Legislators for their legislative acts. Police officers, when they testify as witnesses, can't be sued for money damages, even if they lie under oath and it leads to the conviction of an innocent person. And the president for presidential acts, they have absolute immunity. They can't be sued for money damages at all. But every other government official who violates the Constitution has qualified immunity as a defense. Qualified immunity means that the officer can be held liable only if he or she violates clearly established law that every reasonable officer should know. The court has said it has to be a right established beyond debate. And the court has said, and I'm quoting, qualified immunity exists to protect all but the plainly incompetent officer. And in case after case, the court has used qualified immunity to deny recovery, even when there's a clear violation of rights. Can I give it a recent example? A case that got no media attention from just this past term of the Supreme Court. It's called the City of Tahlequah, Oklahoma versus Bond. A woman called the police that she was felt threatened by her ex-husband. The police came, they found the ex-husband in a tool shed-like area. The man picked up a hammer. The police told him to put down the hammer. And when he didn't do so immediately, the police shot and killed him. His estate sued the police saying, this is excessive force. The officer raised qualified immunity defense. The United States Court of Appeals for the 10th Circuit, headquartered in Denver, ruled in favor of the estate and victim and against the officer. The 10th Circuit said this was excessive force. There's no need to shoot and kill him because he had a hammer in his hand. The hammer couldn't have threatened the officer. They were too far apart. And the 10th Circuit said, no qualified immunity here. This violates clearly established law. The Supreme Court last October unanimously ruled in favor of the police saying qualified immunity. The Supreme Court said that there's no case from the Supreme Court or the 10th Circuit with sufficiently identical facts. Therefore, the officer is protected by qualified immunity. Well, if you ask for identical facts, you'll never find them. There's always some difference from one situation to another, but this is one of so many cases where the Supreme Court has used qualified immunity to rule in favor of the police and against victims, even when their rights are violated. Well, here, even a life was taken away.
So what can we do about it? What is there, how can you fix, or actually, how can we end qualified immunity?
A bill passed the House of Representatives in the summer of 2020, and again this session, that it would dramatically change the law of qualified immunity. Congress can eliminate or revise qualified immunity by statute. That's because it's not based on the Constitution. It's the Supreme Court interpreting a statute, Section 1983. Unfortunately, in both instances, the bill never got through the Senate. So one thing we can hope is that there might be a time where Congress will amend Section 1983 to change qualified immunity. Another thing that can happen is states can create causes of action under state law in state court against police officers who violate people's rights. And the state gets to decide what will be the immunity for state law causes of action, state lawsuits. And they can limit, Colorado has done this, greatly limiting qualified immunity for officers who sued in Colorado courts under Colorado law.
I want to take you back to something you said in your discussion about Wren and the disproportionate impact that the discretion that's given to police officers has on people of color. And at its core, a lot of the case law dictating the rights and responsibilities of police officers comes down to a reasonableness standard in what they think is or is not reasonable in a situation. And similarly, a lot of the reforms we see around use of force, chokeholds, et cetera, carve out exceptions for dangerousness. But in a culture that's steeped in the myth of excessive Black criminality, those exceptions swallow the rule and reasonableness becomes less meaningful to an officer or a jury or a judge. And so I guess the only question that I can ask after that is, what's the fix?
Let me say a couple of things in leading up to fix. One is you're talking about the use of deadly force and how the Supreme Court has said, so long as the police action and the circumstances is reasonable, then the police can use deadly force. And reasonableness is very much interpreted to favor police officers. I think the key is to change the legal standard there. California a couple of years ago said, when it comes to the use of deadly force, the police officer's action must be, quote, necessary, not just reasonable. I think that's an important legal change. And it's key that the officers be instructed that before they fire their gun or use any form of deadly force, it has to be necessary, not just reasonable. Now, I wish the Supreme Court would change the standard, but at least, again, states can do so. And most policing is done at the state and local level. Second, as you focus on reasonableness, something we haven't talked about where the Warren Court was to blame. The Fourth Amendment says that somebody should be able to be stopped by the police, searched by the police, only if there's probable cause. And there's a large body of law giving a sense of what does probable cause mean. But in 1968, in Terry versus Ohio, the Warren Court said that police can stop individuals and frisk them without needing probable cause. All they need is reasonable suspicion, a standard never found in the Constitution. When I teach criminal procedure, my students are always frustrated that the court's never defined reasonable suspicion. All it says is it's more than a hunch and less than probable cause. Unfortunately, what we've seen is this power of the police to stop and frisk is used in a terribly racialized manner. A lawsuit was brought in New York, Floyd versus City of New York, where they gathered statistics over a long period of time and showed how disproportionately Black and brown people would be stopped by the police, and there were much less to be found with weapons or with contraband. Again, there's a place here for state law and state courts. There are some states that reject reasonable suspicion and say any police stop must be based on probable cause. I would hope the Supreme Court someday would do that. But again, I'll give you a fix that can help a bit. One thing that's been learned is if we require every police officer for every stop to record the race of the person stopped, just that decreases racial profiling somewhat. That if the police are conscious that they're going to have to record the race, they're going to be much more attentive to it and less likely to engage in racial profiling. One of the things, the bill that passed the House 2 years ago would have required that all police do this. Some departments are doing it. There's no reason it can't be done everywhere in the country. It's not a total fix to racialized policing, but it's a positive step.
And it's interesting how many of the fixes that you were talking about are really at the state and local level and not at the federal level. But we place a lot of attention on reforms at the federal level. We have just a few minutes before I'm going to turn to audience questions. And so I want to get one in that's a little different from the questions I've been asking so far. Last week, as we heard, we all witnessed history as Justice Ketanji Brown Jackson was sworn into the Supreme Court. And I think there's a lot of pressure on her, with many people thinking she can fix the court single-handedly. And in your book, you talk about the role that Justice Thurgood Marshall's dissents played. And he, more than anyone, showed the power of dissents to make clear that there was another way. The decision was not inevitable, that there could be meaningful justice, that there are alternative visions of justice. I think Justice Sotomayor is following in that tradition. What impact can Justice Jackson have on the court, given the court's makeup?
I want to be realistic, but I'm also optimistic. In terms of realistic, it was a 6-3 court this term with Justice Breyer on the bench. It's going to be a 6-3 court next term with Justice Jackson on the bench. So she doesn't change the ideological makeup of the court this year, or probably next year or the year after. But she's 51 years old. She can be on the court the next 30 or 40 years, and maybe will be 20 years from now. She'll be the decisive justice in a more progressive direction. But also, you rightly point to the fact that many of the justices later said that having Thurgood Marshall there and telling of his experiences, and he was a great storyteller, and things that they had never understood or experienced made a difference in their thinking of the law. And I think that there's the possibility of Ketanji Brown Jackson being the first Black woman on the court might in some cases persuade enough justices to change the outcome. It's not going to be with regard to abortion or gun control or separation of church and state. The conservatives have made up their mind, but there might be some cases where it matters. And in terms of what we're talking about, one area where Justice Breyer was often not with the liberals was with regard to the Fourth Amendment and policing. In the last decade, in a number of important cases, he cast the decisive vote with the conservatives. There was a case, Maryland versus King, but where the police can take DNA from a suspect to see if it matches an unsolved crime in the police database. It's 5-4 with Breyer joining the conservatives and Scalia with the liberals. With the case Agbert versus California, can police stop a motorist solely based on an anonymous tip without observing any erratic driving? In the court, again, 5-4 with Breyer joining the conservatives and Scalia in dissent. Well, I think that Justice Jackson, based on her experience as a public defender, based on her life experiences, is less likely to be pro-police than Breyer. And there'll be some cases where that matters.
The Supreme Court has a big term coming up with affirmative action, as we mentioned, voting rights and many other cases. A lot of my students have lost hope in the Supreme Court. Is there hope in this Supreme Court?
I want to break that down into two parts. Is there hope in this Supreme Court? And is there hope in the Supreme Court? Is there hope in this Supreme Court? Not for the things that you and I care about. I mean, when we look at the decisions the last few weeks, abortion, gun rights, Second Amendment rights, in terms of gun protections, separation of church and state, I have no reason to believe this court is going to be any better next year, 5 years from now, with regard to those issues. When I look at what's on the docket next term, I fear the Supreme Court is going to end the ability of college, university to engage in affirmative action. It's going to open the door for people to be able to discriminate on account of their religious beliefs against gay, lesbian, and transgender individuals. I fear it's going to limit the ability of state courts to create fair elections. But I also, in the longer term, believe there can be hope for the Supreme Court. Maybe the easiest way to put it is, had Hillary Clinton won in 2016 rather than Donald Trump, it's not hard to imagine that. And had she picked 3 justices, Roe versus Wade wouldn't have been overruled. The Second Amendment wouldn't have been expanded into a super right. The ability of courts to create fair elections wouldn't be in doubt. I mean, I think so much would have changed. Well, elections matter, and these justices won't be there forever.
So with that, I'm going to turn to audience questions. And the first one, I think, is a question that plagues us here in New York City, where we have a very powerful police union. How can folks combat, resist the power and influence of police unions who resist policing reform or more fundamental transformations of public safety?
And I think that's a really serious issue. I mean, police unions in so many cities are major obstacles to reform. And I think that the solution with regard to this is to expand city liability for the misconduct of officers. And I'll explain why I think that's the solution. In 1978, in a case called Monell versus Department of Social Services that I discuss in the book, the Supreme Court said that a city can be held liable only if its own policies or customs violate the Constitution. A city can't be held liable because it's employing somebody who's violating the Constitution. That's different from what the law usually is about. Because if, make it UPS has a driver that gets in an accident on the job, UPS is liable. Well, not with regard to cities. I think what we need to do is to make sure that cities are held liable for all of the wrongdoing of all of the officers. And if they have to internalize the cost, I think we give them a real incentive. And now I can tie it back to police unions. I think then when they sit down with the police unions and bargain and say, it cost us these multi-millions of dollars in terms of liability, we can't therefore give it to you in terms of benefits. I think it would give cities the incentive to be strong in the way they deal with the unions.
Our next question, I'm just going to read to you directly. It's a long one. I used to practice in California, and we have the Bain Act and other civil rights specific statutes. California is also a punitive damages state. I now practice in Washington, which is not a punitive damages state and does not have specific state civil rights statutes. What type of state law claims or legislation can help advance state lawsuits against law enforcement so we can avoid being governed by qualified immunity in our 1983 claims?
I think this is such an important question, and it goes to this thing I alluded to before. State law can create state court liability when officers violate the Constitution or when they violate state constitutions and state laws. And the states get to define the scope of that liability, and the states get to define what's the defenses to that liability. So a state can say, we're creating under state law the following circumstance in which you can sue officers, and we're not going to give officers qualified immunity as a defense. As I said, Colorado recently changed its law to take away qualified immunity as a defense for officers who are sued in the state court under state law. And I think this goes to a more general point. So much can be done to reform policing at the state and local level if we can't use the Supreme Court and if we're not going to be able to get Congress to do it. After the death of George Floyd, California passed a law that outlawed police using the chokehold. Many cities adopted policies prohibiting their police from using the chokehold. I can give a lot of other examples where at the state and local level, things happen. Now, the disadvantage is it then has to be fought in each state. It'd be much better if the Supreme Court or Congress would do it for the whole country. But if they don't, there's still tools that can happen.
So our next question is, what prompted your interest in the role of federal judicial system and policing? Was there a specific moment that prompted you to start to research this topic?
I've been teaching criminal procedure and constitutional law for a long time, but I think a pivotal moment for me occurred in 2000 after the Rampart scandal in Los Angeles. And for those who don't remember, it was discovered that police officers were routinely planting evidence in lying in court and gain conviction of innocent people. And I was asked to do a study of the Los Angeles Police Department, and I did it with a group of civil rights lawyers. And as a result, I interviewed about 100 police officers, and I learned a tremendous amount from it about what's the underlying problem with policing in a city like Los Angeles and how to reform it. And wrote a 200-page report that we then published in a law review. But I think for me, that was really a crucial moment with regard to policing. It gave me a much more practical sense. Like you, I'm also a lawyer, and I've litigated a number of excessive force cases. I do it at the appellate level, and I've lost several of them based on qualified immunity. And I mean, one case that I lost involved a police officer mistakenly shot at a car that had 6 teenagers in it. It was just an error by the officer. He killed 3 of them, and the other 3 were seriously injured. And the Court of Appeals, the Ninth Circuit, ruled, well, the officer was protected by qualified immunity. So it's that kind of practical experience that I think also informs my interest in the book.
So we have another question, shifting a little bit. What role does expanding and filling the courts with more progressive judges or more diverse judges play in police reform? And they ask, is it a feasible solution to the court's conservative pro-police bias? And I think that's a question that people have been asking, about reform of the court after Dobbs and some of the other opinions that we've seen come down this term.
On the one hand, I think the only antidote to not having a very conservative court for many years to come is expanding the size of the Supreme Court. Amy Coney Barrett was 48 years old when she was sworn in on October 26, 2020. If she stays on the court until she's 87, the age which Justice Ginsburg died, she will be a justice to the year 2059. The oldest of conservative justices, Clarence Thomas, is just 73 years old. He could easily be on the court another 15 years. So I don't see an alternative, if we're going to avoid a very conservative court, to expanding the size of the Supreme Court. And I understand there's always in the danger Republicans will do it too, but I think the Democrats have to do this unless we want to accept a regressive court for so many years to come. And I think if there were a more progressive court, they would take on the issue of policing in a much better way. Now, on the other hand, I don't think it's realistic. The size of the Supreme Court is set by federal statute. Congress could change that by law, but you know that any proposal to expand the size of the Supreme Court will be filibustered by the Republicans in the Senate. And at least at this point, there aren't the votes to change the rules for the filibuster for anything.
Again, shifting, but we've got you all over the place today. This question says, with the increasing prevalence of data-driven predictive policing, there is, of course, the concern for more surveillance of people of color and more racialized policing. Do you think that predictive policing may also provide an avenue for circumventing lions by allowing individuals to prove the likelihood of future harm as dictated by biased algorithms?
It's a great question. I am very afraid of biased algorithms when it comes to policing or bail decisions or the like. Artificial intelligence has been shown time and again to have biases built into it. But it's fascinating that if you could prove that the algorithm is used in policing and the algorithm bias built into it, then do you have a greater chance of being able to show it will affect a particular person. The difficulty with lions is it says that in order for an individual to sue for an injunction, that individual has to show it's likely to happen to him or her again in the future. And the question is, would an algorithm help that person be able to show that?
Mm-hmm. Yeah, and when I think about lions, I think about stop and frisk in New York City and how frequently certain individuals were stopped and frisked. They were repeatedly stopped and frisked. Do you think that that helps overcome lions?
Yes, I think that if a person can show that they have several times been subjected to the same police practice, that then lets them be able to say to the court, there's enough chance it would happen to me again that I should be able to sue for an injunction. And of course, you point to stop and frisk in New York City. Ultimately, the lawsuit was settled and ended stop and frisk by the NYPD, at least the policies. And what was interesting is there was no increase in crime after the end of stop and frisk.
So the next question, and maybe the last question, is not about policing at all, but goes to something else that we've mentioned in passing, and wants to, the person wants to hear from you about where do you think affirmative action stands, and are we looking at the rollback of affirmative action with the court hearing the Harvard and UNC case in the fall?
As you mentioned, the last time we were together, we were on the side defending affirmative action in front of an audience, and they voted in our favor and in favor of upholding affirmative action. I wish those were the individuals on the Supreme Court to hear these cases in October. It's two cases: students for fair admission versus University of North Carolina, and students for fair admission versus Harvard College. In several cases, Regents, University of California versus Bakke in 1978, Grutter versus Bollinger in 2003, Fisher versus Texas in 2016, the Supreme Court said that college universities have a compelling interest in having a diverse student body. They can use race as one factor in admission decisions to enhance diversity to benefit minorities. The only question that's presented in these cases is whether to overrule Bakke, Grutter, and Fisher. I wish you would tell me I'm wrong, but I don't have any doubt as to what the Supreme Court's going to do. I mean, Chief Justice Roberts has been the most ardent proponent of the idea that the Constitution is colorblind and affirmative action is unconstitutional. He's always been joined by Justice Alito and Thomas. Does anyone have doubt that Justice Gorsuch, Kavanaugh, and Barrett will join them? Now, this isn't the end of diversity. In California in 1996, an initiative passed, Proposition 209, that eliminated affirmative action in the state. And public universities here have had to deal with not having affirmative action. But what's frightening to me is it took over 20 years before UCLA got to the level of diversity that it had prior to 1996. So I worry that there's going to be a dramatic effect in terms of diversity in colleges and universities. I think some will stop trying, and even those that try, it may take a long time to regain diversity. I hope I'm wrong with regard to this.
I hope you are too, but I probably would have given the same response. And I think that's something people may not have picked up with this case, and the potential is that that they're really seeking to mandate colorblind education, and so it puts at risk classes and courses and departments that focus on race. It makes it difficult for applicants who really value their experience as people of color, who have been parts of the Black Student Union, to kind of highlight that experience in their application, because it would no longer be colorblind. So there are lots of risks with this case.
And if I can just add, what you say is absolutely right. The reason there are two cases is one will involve public universities and the other will involve private universities. The Constitution applies to public universities, but private institutions don't have to comply with the Constitution. But Title VI of the 1964 Civil Rights Act says recipients of federal funds can't discriminate based on race, and every private university gets some federal funds. In the Harvard case is where the Supreme Court's going to say any university that receives federal money also can't engage in affirmative action. And so I think here it's going to be eliminating affirmative action, both in the public and private realm when it comes to college universities.
A lot is at stake. I think I'm going to try to slip in two more questions. And the first is, are there specific issues or questions coming up on the next Supreme Court docket around criminal legal system questions that you're concerned about or that we should be keeping our eye on?
Not yet. I mean, one thing is that the percentage of criminal cases is decreased on the Supreme Court side. The whole Supreme Court docket is decreased. They decided only 60 cases this year, 54 last year, 53 the year before that. And the criminal docket is particularly decreased. But there was something that happened this year that I worry is going to happen next year or soon. And it's a case that got no media attention at all. It's a case called Brown versus Davenport. And it involves whether somebody who's convicted in state court and believes that they were unconstitutionally convicted or sentenced can go to federal court with a petition for habeas corpus. And we've always assumed this is permissible. In 1953, the Supreme Court, a case called Brown versus Allen, said anytime someone is convicted in state court and they believe they're unconstitutionally convicted, then go to federal court with the writ of habeas corpus. Justice Gorsuch wrote an opinion joined by 5 other justices, in which he said people should not be able to use habeas corpus for that. The only time they can use habeas corpus, he believes, is to challenge a court that lacked jurisdiction. You can never then raise constitutional claims. It was not the holding of the case, but 6 justices joined it. And I worry it's going to soon be the holding, which will end habeas corpus in the United States.
So our last question, I want to turn it back to your book. And what do you hope that people will take away from reading Presumed Guilty?
It's a great question. Thank you. I hope that people will take away that the Supreme Court bears a good deal of responsibility for the problems of policing and racialized policing in the United States. They really have empowered the police and taken away our rights. But I hope that people, if they read the book, will get to the last chapter where I say there are solutions that can be done. There can be solutions, as we've talked about, through state courts and state constitutions, through the political process, Congress, state legislatures, city councils. There's things that the United States Department of Justice can do. And so we don't have to give up. There can be reforms of policing through many different agents and actors.
Great. Thank you so much. I want to encourage everyone to read Presumed Guilty. It has been an honor to spend this time with you. I'm going to propose that you and I have another session so I can learn your time management skills. I don't know how you are a dean. You teach, you write, you speak. It is amazing, impressive, and so appreciated that you share your wisdom with us.
Thank you so much for doing this. Such an enormous pleasure.
My pleasure.
Thank you so much, Erwin and Deborah, for the truly rich conversation and dialogue, and for Erwin to lending your book and your insights to the national conversation, and for both of you for even the dashes, as minimal as they are, of optimism and hope given the court that we're facing right now. A reminder, you can buy Dean Chemerinsky's book from Marcus Books at the link in the chat, which we'll also send around to all of our attendees and RSVPs. And thank you for joining us and offering insightful questions and your perspectives. Please keep up with AFJ and our upcoming Holding Court events. This is a virtual series we hold regularly, and you can stay up to date at www.afj.org. And thank you again so much to everyone for joining us, and we look forward to seeing you again.